Michael Scott Stone versus Kevin Smith. That's your names?
Michael
Kevin
Scott
J.
Stone.
Smith, sir.
Where are we on this one first?
He has failed to pay me any rent or for the utilities since June of last year and refuses to pay. And I wish you to order a 10-day where he'll be removed by the sheriff within 10 days.
And did you send a copy of this information to him?
Yes, sir, I did. He received it yesterday at 2:33 p.m.
You have the documents?
Yes, text messages and yeah, it's nothing, Your Honor. He's just.
So I'm going to have to set this for trial. I do my trials in person. You're down in Florida. He's here. When I read through them, they're at least what potentially could be colorable defenses. I don't know until I hear the testimony.
Your Honor, I'm a working man. I make $24 an hour, and I'm paying his rent and utilities.
Sir, you know, every time you come here, you try to tell me how this is going to be.
No.
You have property here in Michigan. You may be down in Florida. You may be a working man. I consider myself that too. This happens to be my job. Part of my job is setting a date for these trials to get them resolved. Now, if what you want to do week after week is sit here and try to lecture me on what Michigan law should do, then I'll just keep setting it every week. He'll come back. You'll just try to give me that lecture and we'll just move on. I'm trying to resolve the case. So I'm going to set a trial date.
So today's not the trial date?
No.
Okay.
I'm going to set a trial date. Maybe you didn't appreciate what I said. That trial date will be in person.
Well,
if you had listened to the case before, I realize there are people out of state. I will try to accommodate that the best I can. So I'm going to set a trial date in person. I can set it for February 18th or March 11th.
Your Honor,
your preference?
Can I have an attorney represent me there?
February 18th, sir. The reason being is because
I don't care. I didn't ask that. Can you be here February 18th, sir, for a trial?
Can I hire an attorney to represent me there?
Pardon?
Can I have an attorney be there present for me?
Absolutely. You can have an attorney here.
Okay.
That might be wise, because then I don't get lectured.
Yes, Your Honor. So,
non-jury trial in this matter.
Your Honor.
Will be set February 18th.
Yes, Your Honor.
2025, 9 a.m. in person. I will allow testimony over Zoom, but there needs to be a party here. Yes, sir.
On what basis is any of this evidence going to allow him to continue to stay there free? I don't understand.
Pardon?
There's nothing in any of this that it gives him the right to continue to stay there for free. I don't understand.
Then get an attorney, and then maybe then you'll have some clarification if you listen to him.
Okay. I don't understand his claim of how he can continue to stay there for free. There's nothing in those papers.
Okay, just because you rephrase the question doesn't change my answer.
Okay. All right. So I will have an attorney.
Sir, you had a question?
Not a question, Your Honor. A statement that I would like to make, please.
Oh. About what?
Mr. Stone and the status of the condominium, sir.
And the status of the condominium?
Yes, sir.
In terms of, go ahead. It's got to be brief, and I may cut you off.
Yes, sir. Very brief, very short. Mr. Stone has known since, I'm sorry, Your Honor. Mr. Stone has known since 2022 that he should have the place registered as a rental property. Mr. Stone received.
That is a defense, and that you will raise at a trial.
Yes, sir.
I set a trial date, and God help me, I'll be here to hear all of it.
Yes, sir.
18th.
9 a.m.
9 a.m. in person. Thank you.
Yes, sir.
Yep. Okay. Go. Will you hand me my screen box?
Now go. Preach.
Ain't fucking going through. What the fuck? Why isn't he giving me anything? sitting here. Like, the traffic, I don't even know if it's going through, but I told him it doesn't go through upstairs.
You can sit in a room.
Huh?
You can sit in a
You don't, you can't, the traffic, it interferes.
Close the door.
I do. You can hear the traffic, and it keeps, and now it keeps going, hey, you're unmuted, you are muted, you are unmuted, you're muted. So I don't know if I'm even on it. I've done this before up here, and it doesn't go through.
We can hear you. You're in here. Just mute yourself.
Oops, I guess it doesn't go through.
Sycamore Meadows versus Caleb B.
Again, Carrie's in
Jill Bauer on behalf of Ms. Peace is also present.
All right.
Judge, I know that last time I wasn't here, I got an email from opposing counsel regarding a stipulated order. I sent her a revised stipulated order as to what my client would be willing to agree to, meaning to give Ms. P sometime a date where she can get everything out of the unit and she can take anybody that she needs to take with. We're just asking that they wear appropriate face coverings because of the situation. I wasn't here. I heard through the grapevine of what happened. I just want the court to be aware it's about insurance bids. I mean, realistically, insurance bids and contractor bids and making sure that we have the appropriate people in the unit. All of the things need to be removed, Judge. It's soot filled. There's a wall that needs to come down. Am I correct? There's a whole wall that actually needs to be replaced. So it's not something where counsel wanted Ms. P to be able to leave items upstairs. That's a problem because the smell is going to stay. You know all of the things I'm going to say to you. And so I really just need all of her stuff out and then they can do what they can do. And that's where I'm at. That's what I can agree to at this time. And I sent that order over to opposing counsel for review and they can pick a day.
Well, Your Honor, if they're willing to rehouse her, she would have a place to remove her belongings too. But she's living in her car right now.
Judge, I don't think that's quite accurate because my client has actually seen her with her grandma, who's also in Sycamore Meadows. So I could be wrong, but I believe that that's where they've seen her living and residing. At this time, Judge, I don't have the authorization to agree to rehouse her, and I don't think that my client's willing to do that either from what I've been told at this point. So I'm willing to give her the time that she needs to get her stuff out of there so they can get in the unit and do what they need to do.
And we believe that they should be rehousing her. So we'd ask the court to.
But she's not in the unit. So I guess I'm unclear as to why you're holding the unit hostage.
Well, we're not really holding.
Put it bluntly. I mean, because that's what you're doing. I mean, they can't, if her things are in there, they can't do anything. And so I don't know who that benefits.
Well, Your Honor, I was not aware that it seemed to me that the damage was just in the kitchen and that there wouldn't be any work being done upstairs. So that's why I thought she could leave her large items upstairs because she has nowhere else to put them right now. If she was rehoused, she would have a place to put them. That's what I was thinking. I did not have the information that a wall needed to be replaced. That would make it untenable to store things on the second floor.
Okay. So now we are aware that that's the case. So what's defendant's position now? Because whether she's rehoused or not, you can't just hold this unit. I mean, I can issue an order that she has to remove her items or she's at a certain date they're abandoned and then they can remove them.
Well, I just heard with you that the second floor. So can I ask her if she has a place to move the larger items? Your Honor, Ms. P has items in the unit that she wants to remove, but she's willing to not take the larger items because she has nowhere to store them. But she just wants the court to be clear that she's not surrendering her right to the unit. She's just removing her things so that repairs can begin. That's what she's concerned about.
At this point, I think I've said it already twice now. My client's not willing to rehouse her. I don't, at this point, I just need her to get the stuff out so that we can get done what we need to get done. This isn't the first fire that took place in this unit. This is the second fire. So there's problems there, but I think before the court today is what we've discussed about removing the items. And so that's where I'm at.
The order that was sent over regarding removal, what was the date?
I just need her to pick a date. And so that the order says that within the next week, she'll pick a date and she'll be able to go on that date and bring individuals with her. Can I see the?
That's my order.
Okay, Judge, I sent it to her. I thought it was one paragraph, Judge, and I'll read it to you. Defendant shall be provided a full day within the next week to go through her belongings and remove any and all belongings from the unit. Defendant shall be allowed to bring people with her to assist her. Defendant and anyone going into the unit shall wear protective clothing and mask while in the unit. So order. And if she wants to pick a date now, I can revise it and put the date and the time she'll be able to be there.
Give me a date.
She needs to talk to find out who can help her, but she will pick a date.
Okay.
For the 7th of February, so within the next week.
Okay, so here's what I'm gonna do. I'm not this way. Can't pick a date, I'll pick a date.
Okay.
It was February 6th.
Thank you, Judge.
Thank you, Judge.
So put that in the order, I'll sign the order, and then what do I need to do? Adjourn this case out to deal with the.
I have two other things that I want to put on.
Sure.
I'd like to add an explicit sentence to the order that clarifies that she's not giving up her right to be housed by emptying out the unit.
Well, if the case continues, of course she's not. She's
Okay.
challenged. I don't know why that needs. to
Okay,
be
I just
there, but
want that to be part of.
Otherwise, she'd get her stuff out and we're done, but obviously we're not.
Okay.
I'll be
The other.
handling this when I get Social Security, apparently. Go ahead.
Okay. I think that the stove should be preserved for examination, since that's the key item about how the fire started.
The stove should be preserved.
And we'd like.
Is the cat gonna testify? I'm sorry. I thought I'd ask.
Judge, there's pictures of the stove and with the, I think they're attached to, there's actually pictures and in the fire report with showing that the stove was actually on, that the knob was on to turn. So I don't know what.
Yeah, I know, but the issue is whether or not a human being turned it off.
I don't know what the issue is, Judge. I understand very, very clear my issue.
I'm not sure how we're gonna resolve that, but
I'm not either,
I'd
but
like an opportunity to see if I can find someone who might be able to weigh in on that.
I don't know how
is
this,
this cat still available? I mean, I just asked you a question because do you still have the cat? Okay.
Judge, I don't know how she wants me to preserve the stove. I have no way of preserving a stove. So unless Ms.
Well, I would imagine that Sycamore Meadows has some storage. I mean, I get the request because somebody's gonna have to show me how this.
There's actually a statement in the report from the fire chief that Ms. P said that when she walked in and saw the smoke, she heard the clicking of the stove and then walked back out as well. So I don't know how preserving the stove is going to change any of the evidence that's out there, but.
Are you want the stove preserved for what purpose? To determine whether or not there's
It could
some.
be started by an animal. I mean, that's what they put in their motion that I got yesterday.
But
Is
that's
that-
what was in the, I didn't put that in the
But
motion.
that was a statement, I think, by your client
But-
to the fire.
But she recorded the conversation with the fire department. That is not what she said. So the fire report is not accurate.
Okay, well, to make it fair, you guys are gonna have to find some place to store the stove. The stove, prepare an order, gotta preserve the stove as well
If my
as,
client has no place to put it, what would you like me to do? Does Miss Bauer want to find somewhere to preserve it? Judge, because my client doesn't have storage. If they, I mean,
can you guys work out where to store it? I mean, because obviously somebody's gonna have to pay to have it. Or
why doesn't she?
what do you want to do to this stove? You want somebody to go and tell you whether or not this stove can be turned on by an animal, right?
I'm sorry, Your
So-
Honor, could you repeat that?
I know, Miss Lee was all in your ear. So when would you get the person out?
I'll start working on it immediately. Maybe the stove could be moved to the basement since there's not going to be any work done in the basement.
Well, I don't know that. I mean, I'm not the contractor, so I don't know whether or not it's,
I mean, if
okay, so I'm going to be serious about this for a moment. The stove needs to be put in some secure location. All right. You're just going to have to, the plaintiff is going to have to figure that out.
that's fine, Judge. I'll figure it out.
Okay.
And then the last thing, Your Honor, is I finally got paperwork for the case this week. I'd like to file an answer on behalf of Ms. P. I need time to file an answer to the motion that I got yesterday, and then possibly draft my own motion for summary disposition. So I need time for those things with permission of the court.
How much time are you going to need?
I would like 3 weeks. I don't know if the court would give me 3 weeks or not, because I still have a FOIA request that I'm going to be picking up today that seems to be pretty lengthy.
Judge, we're before you on the 18th of February. You can stick us on that date. If you're okay with it.
Probably not, but
Okay.
I mean, I will. But here's what I'm going to do. I'm not giving you 3 weeks. You need to file it by the 14th.
Okay. Thank you, Your Honor.
And then I will adjourn this matter out. We can put you on the 18th.
Okay, thank
And
you.
then we'll figure out where we're going. February 18th, 2024, 9 a.m. That's in person. You prepare the order regarding preservation and you prepare the other order and then I'll sign it. Thank you. I do also want a picture of the cat's front paws.
Can I just make sure that the things on top of the stove don't need to be preserved? You just want the stove put in a location in the basement or something
Yes,
like that? I can get rid of all of this, correct? Because I'm not gonna be able, the
Yeah.
problem with preserving everything that's burnt on the stove is the same problem with all of the stuff.
I don't
in-
think we have pictures of that. I think we're just interested in the mechanics of the stove being able to be examined. So that's fine.
Okay, thank you,
Okay.
Judge.
And I want pictures of the cat's front paws extended as well as the rear paws. Not that those are as important for me.
Okay.
Thank you. Sycamore Meadows versus Christine Mason.
Okay, here's the plaintiff.
Your Honor, we've been trying to work out this case without representing Miss Mason, but we just made.
I don't know how you do that. I get it, but
We're gonna enter an appearance because there are significant issues with her ledger. All of the charges that are being assessed against her go back to previous management. They don't align with her income. They haven't been able to produce research.
so are you filing an appearance?
Yes, gonna be filing an appearance.
And then you'll file an answer and
Yes.
will you do that?
We can file the answer on this one probably by next Thursday.
We have a judgment on this one. This is a problem I have, Judge, we've adjourned this now a couple.
You're
We
right.
have a judgment on it. We've adjourned this a couple times because Ms. Mason was trying to get funds. I'm understanding that I thought she was approved for Hawk. Am I incorrect? 3,000 for Hawk, correct? And then you were approved for another amount, 200 from another agency, because the last time we were here, which was, I believe, a week or 2 weeks ago, she was just trying to come up with the balance. And so now we're making it more convoluted. And I'm just, if that was the case that they wanted to do, why didn't they do it in the beginning? 4, 6, whatever weeks ago it was. Why are we doing it now when Ms. Mason has put on the record multiple times she's just trying to get the funding, and obviously we're working with her?
Well, we were waiting for documents and we didn't find out until last week that they don't have the research that we were asking for. So then I had Ms. Mason provide us with tax returns, and we see that the amount of rent that she was charged is way out of alignment with what her income was for the years that this balance accrued. She's been on zero rent since January of 2024. So this is all old. These balances are all from prior management that can't be justified with paperwork.
Requests were made. I went to client. They don't have them. Previous management had them and didn't leave them in the file. I indicated that to them. However, again, I'm sitting here and they could have filed an appearance multiple times ago, and now we're doing
Well,
it.
until we didn't know that the documents existed, we didn't know that we had to go about challenging the balance in a different way.
I guess my problem is we're submitting paperwork or ledgers for a balance, but now we're saying we're going to contest the balance. So when we're submitting it for us assistance and funding, it's okay, but now it's not because we don't have enough to cover the balance. I find that all a little disingenuous as well, but
The judgment amount back in December was 5179. As we sit here today, I don't know what her January was zero, correct?
Yes, Your Honor.
the balance is actually a little bit lower than that, Judge.
It is. What is it now?
The total with the court costs would be $5,004, Judge.
Okay, so now we're at $5,004 that's owed. What that means, and I'm trying to figure this out, but I thought, as was Zanin has said, that it was really an issue of finding the money and giving time for that to happen. So when I look back at my notes in the file, I'm a bit surprised that we'd be at this point, because if 3,000 comes from Hawk, there's 1,000 in escrow. I now have $1,004 that somehow we find, but now want to go into everything. And I don't, and quite frankly, I'm not even sure how we would figure all of that out without just a guess. Because you're going to go back, you're going to use tax returns. The documents don't exist. Previous management isn't here. So I don't know if she complied with her part of recertifying, or it was management. I don't even know how I would figure that out.
Judge, we're actually at $800. If I show $5,004, 3,000 Hawk, 1,000 in escrow, plus 200 is the other agency that.
Oh, right.
So
Right.
we're at $800.
Your Honor, all I can say is that until last week, we didn't know that we weren't going to get the documents to review the ledger. For example, in 2023, her total income was $7,800 and she was billed $500 a month in rent. And if they had been properly doing her recertifications, that would have been caught because she lost income in December of the previous year.
Was that reported? I mean, you're asking me to make certain assumptions about things that I'm not sure, even if given a trial, I could make those assumptions.
Your Honor, I think if they had been properly recertifying her, they would have checked her income at the time of recertification and seen that it was much lower than the amount of rent that she was being billed.
And sometimes people lie on their tax returns. I mean, what do you want me to, I mean, that's going to be part of the problem. You're asking me to just default to that side, and I don't know that I can.
Judge, we actually have we have a stepping stone, the default judgment.
Pardon?
We have a judgment that's in place.
Oh, I know.
Oh.
I know.
Yeah.
I know. I mean, I'm just,
And there's a court rule that's very clear about,
I know.
okay,
Your Honor,
Thank you. Thank you for reminding me of my job.
and I'm not trying,
No.
I'm just making my arguments.
No, I understand.
Your Honor, procedurally, it's the plaintiff's duty to prove that she owes what they say that she owes, and there's a motion to set aside.
No. You have to give me, we're at a point in this case where you have to give me a defense. You have to give me a meritorious defense for me to set aside this default judgment.
And that's what I was wanting to do, is enter an appearance and provide an explanation of why we think the judgment amount.
Okay, but Spauer, here's my problem with this. We go through a process of trying to preserve people's house. They don't appear at the second hearing or the first hearing. We then come later on and everybody is sort of in agreement, and where you guys come into the case, say you're not going to enter an appearance, and I guess get that maybe, and that it's really about just getting the amount. And so the whole process through Hawk, and I won't go into my feelings on the time on that, but it works itself through. She gets the $3,000. She's posted herself $1,000 into escrow. There's $200 from some other place. And then we get to this point, and then the argument becomes, well, the number's not right. And, my frustration is that, quite frankly, I really don't want to play games with this. What I want is Ms. Mason's tenancy preserved if it can be. And I thought that's where we were all headed. But it seems like now where we're headed is that we're going to have litigation on litigation about what amount is due. I mean,
There's still an $800 gap that may be able to be addressed with inaccuracies in the ledger, and then she would have assistance to cover the rest of the balance, and her housing would be preserved. But she's still short $800.
I know. And so while I'd be sitting here trying to figure out, do math in a ledger of something that, quite frankly, as I anticipate, I'm not going to be able to determine, what efforts are being done to get the 800? Because she's currently at 0.
Yeah.
So it seems to me that all of this effort should be spent getting that money in between.
We are, we're trying, we're working on multiple fronts, Your Honor.
Okay. So she filed her motion regarding the default. Of rights right now, I could deny her motion. After all of this work, I could just deny her motion, and then the writ goes forward. And where have we got Miss Mason? Pardon?
You said, where have I gotten the rest of the money?
No, what I'm saying is,
No, we don't want her to lose her housing, Your Honor.
I know, and that's what I'm trying to point out. I've got this figure. So if we want to play the procedural game, we can. Or we can look at just doing what I thought we were doing. So I'm going to pass the matter Ms. Bauer, you can talk to your client and let's figure out what we're gonna do.
Okay, thank you, Your Honor.
Court does call the case of Sycamore Meadows versus Christine Mason. You're welcome.
I said.
All right.
I said it, just not very loud. Carrie Zanon on behalf of plaintiff, Your Honor.
Jill Bauer on behalf of Ms. Mason, Your Honor.
It's my understanding that they've submitted a request for some funding for 800.
Did it.
Yeah. Fervently typing. When she was fervently typing, she was sending a request for some assistance for
The balance.
So if you could give us an adjourned date, I think we'll have this resolved.
No, you will have it resolved.
You're-
February 14th, 2025 at 1 p.m.
Thank you.
Thank you.
Have a wonderful weekend, Judge.
Donald Heyman versus Angela Heyman. Is it Chenard? All right. Okay.
Yeah.
State your names.
Donald Hammond?
Angela Schnard.
All right. This is a termination.
Mm-hmm.
All right. And what's your response to the termination?
Okay.
Pardon?
I'm not sure what to say, but okay.
All right.
Or,
Go ahead.
Doctor or her worker, caseworker is Mrs. Chaplin, and she is working with her to get her help.
Got it.
I don't know how.
I haven't been able to work since I moved back into home. Parents haven't been able to work.
Okay, let me ask you this. What agency is your caseworker through?
Not sure.
Adult.
Taking care of everything against me, against my will.
Pardon?
Oh, go ahead. I'm just saying he's taking care of everything against my will.
Who takes care of everything?
He has been trying to, I don't know.
Okay, hold on a moment. What's the relationship here?
I am her father.
Got it. Okay. And why do you have a worker?
I'm not sure.
Okay, Dad, can you?
Adult Protective Services. She has problems with. I'm okay.
Got it. Regardless of what that was, the state stepped in for her.
Mental capacity.
Got it.
Trying to keep it clarified.
So the state stepped in.
Yeah.
Got it.
And that's where Mrs. Joplin came in.
That's what I was trying to figure out. Okay, got it. And so they're trying to find her housing.
They want to find a guardian.
Wow.
I have leukemia, so I'm not capable of it to do it. So Mrs. Joplin is trying to get her a court-appointed guardian or counselor, whatever you want to call them. And she has started getting her state help.
Got it. Okay, thank you. So do you know whether or not a petition in probate court has been started?
I have not been informed one way or another about it.
Okay.
All I know is Mrs. Joplin is taking care of it.
Trying to, okay.
Yeah, trying to take care of it.
Okay. And you know about that? Has she talked to you about that? Okay.
She has been to the house and she has talked to Angela about it. But Angela does not seem to be
A little bit.
responsible.
To Ms. Joplin?
I've been responsive.
Okay. So, okay. All right. I don't know that fathers and daughters always often can disagree about that. So I'll just let that happen.
Right.
I moved in and I was helping him out the house, housekeeping. And when he had leukemia, real bad, I was helping him with that.
Okay.
Giving him his medication for that. And
Okay.
it everything, then I'm like kicked to the curb, you know.
Okay, all right. So, Ms. Jacqueline, if you asked her, do you think she'd come to court with you?
I had told her about the hearing today. She was going to try to make it. She must have gotten tied up.
Tied up or something. Okay, because I don't, given what's being said, I'm a little bit hesitant to proceed. I'm a little bit hesitant to proceed with anything today
That's fine.
because I want her here. So here's what, young lady, here's what I need you to do. Whether you think what's happening is right or wrong, okay? You need to communicate to Miss Joplin that she needs to be here at the hearing, okay?
I need her phone number. They didn't really, they haven't given to me to keep in touch with her.
Okay, but doesn't she, have you talked to her?
She would just drop in and talk with him first, and then come up to my room and then talk to me.
Talk to you? Okay, so here's, okay, all right, I got it.
Talks to him, and then
So,
that's how it goes.
so here's what I want to have happen. Dad, if you could let her know, I get that. And then after, when she shows up to talk to you, I need you to tell her that you need her at the hearing also. Okay?
Yes, sir.
So let me adjourn the hearing in this case. I'm going to go February 21st, 2025 at 2 p.m. And I'm putting it out a little bit longer just to give enough time for her schedule for its packed.
Thank you.
And then also what will happen is if there is a petition that's going to be filed, that will also give hopefully some space and we'll be able to figure it out.
Okay.
All right?
Okay. Thank you.
Well, court calls case, the people are Jared Lepick versus Andrew Elliott.
Hello, Your Honor. I'm Jordan Lepick. I'm also on this case. Jared Lepick
Yes.
unfortunately was diagnosed with influenza A this morning, so he has his Zoom going and can mic in if need be, but he's got very little of a voice at this point.
Okay. All right. And yes, I do see him signed in. All right. Andrew Elliott or Traversia, is it Burrell?
Traversia Borelli.
Okay, sorry.
That's
All right. Okay, what are we doing on this case?
Last week, sir, you had asked if they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There's still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th. And the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part, stating that he can provide the court of a copy with this email. In his own words, he states, "We will obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor." In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he's offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely.
All right. How much are you claiming is owed?
So as of right now, he owes $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I don't know that I'm necessarily going to need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out. presently under the supervision of the land manager.
Okay. So, and ma'am, are you disputing the amount they're claiming is owed?
I am.
You are?
Yes, I am. We
Okay.
owe.
How much do you think you owe?
So we owe December and January. That's $10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor,
5,000.
monthly rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the sale.
Okay. So here's the thing. Is she right about, she just listed off, I think, $4,000 of late fees that they paid?
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of the months under those leases. And I can submit documentation of all this, sir.
So can I.
All right.
I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th, and I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
okay, look, folks. Oh, ma'am.
Yes.
Here's what's going to happen. What date are you going to be out of the premises?
We're already out.
Your stuff
You're
is
already
still
out.
Right.
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or 2, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your
look,
Honor.
folks.
Your Honor, I'm
Yes.
in my house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've just been sitting in my house, sir.
This is incorrect.
Okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So possession is not.
Sorry.
Pardon?
There are still people at the house. One of them had a residence established there, apparently. They're still at the house, and unfortunately, our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay. So here's what I'm going to do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes, there
Ms.
is.
Burrell, are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just using my phone to do this.
Possession to the premises has been surrendered. Ma'am, as of given everything that I'm hearing, your management contract expires at midnight tonight? Is that the deal, or?
Yeah, yes. And we can't afford to pay
All
a
right.
property manager anymore.
Hang on. I hear you. I'm just trying to, because you're in North Carolina, right?
Yes, sir. But I will have to make
Okay.
a trip up to North Carolina to assess anything.
I know. I'm just, I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk and then I'll just go back and then come back out. Because either you're going to listen to me or not. Possession's been surrendered. I'm going to give the authority, I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3:00 today. The reason I'm doing that is so that you can get your property manager, go over there. You can order a locksmith. You can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys, they giving you grace to get some of the stuff out. If it's not out, not out.
That's
But the
perfectly fine, Your
premises
Honor.
will be locked.
Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day. Enough.
So if I I was just going to set this for a trial. So I can set a trial date, but I'm going to need the parties in person because apparently there's going to be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date? March. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip. But I've just tried to put it out to, well, I think you get what I'm saying. Okay?
Absolutely.
But I'm allowing you to secure the premises. You're going to come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Your Honor, might I ask one question?
Sure.
Rather than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of of essence.
Got it. Then the best I could do is the 18th. What day? Yeah. The best I could then do is February 18th. I could push it up to that day. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay.
And one more question. Will Mr. Lepek have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare, work, those things. I would allow him to appear via Zoom.
Thank you. And as far as
so that he's present, but you will have to be here in person.
Understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I got to do.
Okay, thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same, okay. I will give you the same opportunities that I give the other side in fairness. So you may appear, but he would have to be available via Zoom.
Okay, thank you so much.
Thank you.
Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What? What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.